are aware, on the 13th of February 2025, Ferdinand Waititu was convicted under the Anti-Corruption and Economic Crimes Act, and pursuing his right of appeal, which is the ordinary course of justice, he has instructed us to pursue the appeal on his behalf, and we have done so by raising very many grounds of appeal, amongst them being that the trial court and the trial magistrate did not take into account a wide array of evidence brought into his defense, but in the event or other part went on to consider the prosecution's evidence only. As time will show, and the appeal will show in due course, that we are keen on securing a safe and practicable solution, which is justice to Ferdinand Waititu. So we have also been able to file an application for bail pending appeal, and as you are aware, that the High Courts have been so grateful and have been instrumental in ensuring the right to liberty despite a conviction being passed by a trial court. Therefore, we have moved the court under the same provisions, asking and demonstrating to the court that Ferdinand Waititu, as he is being a convict, has the right to liberty, which the Constitution of Kenya secures and guarantees every right, or rather guarantees every person of that right. And I wish to also say that being a convict by a trial court does not in any way mean that you are guilty until all the avenues of appeal are exhausted. Thank you.
Well, thank you, members of the fourth state. My brother Stanley Kinyanjui has quite summarized the events of the 13th day of February 2025. Now, over the weekend and from when the court rendered its decision, we've had an opportunity of going through the entire judgment, the 212 pages judgment, and the conviction as rendered by the trial court on the 13th day of February 2025. And there are a number of issues that have come to light, which have given us the encouragement that indeed there is the wisdom in having the number of courts up above the subordinate courts, so that the High Court can have an opportunity of going through the record again and appreciating that indeed there are a number of mistakes that have been committed. In our memorandum of appeal dated the 14th day of February 2025, we have come up with numerous grounds of appeal to suggest that indeed there is an arguable case that we can make at the appellate stage, so that we can have the judgment, or rather the decision to convict and sentence Honorable Ferdinand Waititu, alias Baba Yao, set aside or disturbed for that matter. Over and above that, there are numerous exceptional circumstances that will ordinarily warrant the release of Ferdinand Baba Yao Waititu on cash bail or bond pending the hearing and determination of the appeal that we have filed. As you are well aware, on 14th day of February, when you were celebrating your Valentine's Day, Baba Yao was taken ill at the Kenyatta National Hospital, and he's since been recommended some medicines so that he can tone down some of these challenges that have now resulted after the conviction that was rendered by the court. So we are hoping that for us to save a life, for us to avoid a situation that befell one Kakuyo in the later days when he was convicted, and later on, when they filed an application for bail pending appeal, upon his denial, he died when he was in police custody. So we are hoping that the court, at the very least, will first make a declaration that he be released pending the hearing and determination of the appeal that we have filed, so that in the fullness of time we are going to persuade the court that indeed there are errors that were made by the trial court that will disturb or lead to the disturbing of the finding of the conviction and the sentence that was handed down to to Ferdinand Waititu, Baba Yao. Thank you.
From where my colleagues have left it at, and I wish to say this. In the trial before the subordinate court, Baba Yao was being represented by a different team of lawyers up till the conviction was obtained. It is only after the conviction that we were instructed to come on board to see to it that we analyze, sift through the evidence that was tendered before the subordinate court for us to come up with grounds and see if those grounds merit an appeal. Now, we have since perused the proceedings and judgment of the court, including the sentence, and we have come up with one singular decision and opinion that this is a case that merits an appeal, which appeal has already been filed. Alongside that appeal, we have also equally filed an application for bond pending appeal. Now, what that means is that we are going before the judge in the appellate jurisdiction for purposes of now that judge going through the evidence and seeing to it whether the appeal merits Baba Yao to be out on bond or continue to be out on bond on the terms that was on in before, as we process the appeal, which will be heard at the later stage. Now, several grounds have been raised. Without going into the merits of what has been raised in those grounds, we feel that it is important that the country knows that Baba Yao has been convicted on errors apparent on the face of it. Those are the errors that we're going to analyze and present before the appellate court, so that the appellate court can be able to see from our standpoint. Now, speaking of the bond pending appeal, the law, that is the Criminal Procedure Code, allows for any convict to ventilate an appeal, and as that appeal is being presented and being heard, the law provides under Section 357, which you have moved, that is the Criminal Procedure Code, that that party can be granted terms. Now, remember, there is the presumption of innocence in our laws, but Baba Yao has since been convicted. It means, therefore, that the threshold of that proof beyond reasonable doubt has been exhibited by the prosecution, but we are going to overturn that in the appeal because of the grounds that now we have raised.
Well, Baba Yao has put the mother of all battles to save his life. Two issues come up. One, we have gone to get him out purely on two grounds before the appeal is done. One, on medical grounds. This is a man who is above 62 years old, suffering from chronic fatalistic diseases. We have provided evidence from Kenyatta National Hospital and the prison medical facilities. We are seeking that he be released to attend to his medical conditions as he is outside. Number two, we are also looking at the judicial sentencing policy. At 62, with such medical conditions, can the facilities called prison be able to keep this man alive for him to see justice be done to him? Third, we have filed a substantive appeal. This appeal raises over 57 grounds to ensure that Baba Yao is free to continue his politics as this matter proceeds. Remember, Baba Yao is a politician. Baba Yao is a citizen of this country. Baba Yao is protected by the constitutional provision of this country. This is not the first time the High Court and the Court of Appeal has released people who have been convicted by the ethics and anti-corruption courts. So we are relying, for example, on the Waluke matter. For example, this was the team that was part of the Waluke defense team, and we hope that we will be seeing Baba Yao coming out very fast.